Hello and welcome. Today we're diving into a really fascinating constitutional safeguard. Think of it like a watchdog, designed to catch lawmakers if they try to, bend the rules in secret. It's a principle that asks a really simple question. Is a new law actually what it says it is, or is it just wearing a clever disguise? So, picture this. A government is told, point blank, by the Constitution, that it can't make a law about a certain topic. The line is drawn in the sand, right? But what if they try to sneak across that line anyway? What if they pass a law that looks totally legitimate on the surface, but its real, secret purpose is to do the exact thing they were forbidden from doing? Well, there's a pretty serious name for that kind of legislative trickery: a fraud on the Constitution. It's a huge deal. But our Constitution has its own built-in lie detector, a tool specifically designed to see right through that disguise and protect the fundamental rules of making laws.
Okay, so how do you unmask a law that's basically wearing a costume? The answer lies in a legal doctrine that has a perfectly fitting name.
And here it is, the doctrine of colorable legislation. Now, at its core, this isn't about whether a law is good or bad. It's all about competence. It boils down to one simple question. Did the government that passed this law actually have the authority to do it, or did it secretly step over its constitutional line? This whole idea is actually rooted in a very old Latin legal maxim: quando aliquid prohibetur ex directo, prohibetur et per obliquum. It's a timeless piece of wisdom that just means if you're not allowed to do something directly, you can't use some sneaky, indirect path to get it done either.
To really get how this doctrine works in practice, we've got to first understand the rulebook, the constitutional blueprint that divides up lawmaking powers in India. It basically assigns different jobs to different levels of government.
And that specific rulebook, it's Article 246 of the Constitution. This is the article that lays out the boundaries, clearly separating the powers of the central parliament from the powers of the state legislatures. This division of power is all spelled out for us in the 7th schedule, which creates 3 distinct lists. You've got the union list for the central parliament, which covers big national things like defense. Then there's the state list for state governments, which deals with more local stuff like police. And finally, the concurrent list, where both can make laws. This whole doctrine exists just to make sure nobody starts coloring outside their own lines. So what happens when a law gets challenged? How do the courts put on their, X-ray glasses to see through the disguise? Well, they use a very specific test to look right through the surface. The court's test has 3 really key parts. First, they look at the law's pith and substance, what it's really about, not just what the title says. Second, they figure out its actual effect in the real world. And third, and this is so important, the motive doesn't matter. It doesn't matter if the intentions were good. The only question is, was the legislature competent to pass the law? Now, this table helps clear up something people often get confused about. The doctrine of pith and substance is used when a law just accidentally steps into another's territory. It's meant to save the law if its main goal is legit. But the doctrine of colorable legislation, that's different. That's for when you suspect the legislature deliberately put on a disguise to grab power it doesn't have. So one is like an accidental trespass, the other is more like a planned fraud. I love how the Supreme Court put it in a big case. They said that even if a law has the mark of competency on its face, if the legislature was actually clumsy or incompetent to make that law in substance, then it's a colorable enactment. The court is pretty much saying, nice try, but we see what you did there. But hey, this powerful doctrine isn't some magic bullet. It's a really specialized tool, and you can't just use it in every single situation. So it's super important to know its limits. For example, it doesn't apply to rules made by government departments, only laws passed by the main legislatures. It also can't be used when a legislature has, total and unlimited power over a subject. And again, it's not a tool to ask if a law is a good idea. It's only about whether the legislature had the power to make it at all. So what's the bottom line? The crucial point is that the doctrine of colorable legislation is so much more than some abstract legal idea. It's a really practical and vital safeguard. It makes sure that the careful balance of power that the Constitution drew up between the Union and the states is actually protected, preventing one from sneaking onto the other's turf. And all of this leaves us with a much bigger question to chew on. This doctrine is one really powerful check on legislative power, but it makes you wonder, right? In a democracy as complex as ours, what other kinds of safeguards are absolutely essential to make sure power is always used transparently and kept within its proper constitutional limits?